Afternoon, everyone. Thank you for joining us for the District of Columbia Freedom of Information Act training. I am Sheree DeBerry. Welcome to OOG's FY 2023 DC FOIA webinar series. This will be our 5th training. We have 2 webinars remaining, and they will take place on July 25th and August 1st. Please feel free to ask questions as we move along in the presentation. You may also submit questions in the chat. Hold on. The screen is not advancing. Hold on 1 second here. Here we go. Today, we will discuss the District of Columbia Freedom of Information Act. We will focus on acknowledgement letters, the importance of acknowledgement letters, FOIA fees, requester fee categories, as well as decision letters. The District of Columbia Freedom of Information Act gives the public the right to request records from district government agencies. Agencies must release the requested information unless the information is protected from disclosure. And our FOIA exemptions protects certain types of information from disclosure. The District of Columbia Freedom of Information Act has an affirmative disclosure provision. DC FOIA requires agencies to proactively post public information on the internet. Some examples of public information include administrative staff manuals, final opinions, and policies. This information should be listed on the agency's website under the Freedom of Information Act tab entitled FOIA. opendata.dc.gov is a district government site that is a great resource to check for public information. The district has proactively released hundreds of data sets, and they are available on opendata.dc.gov. Who handles FOIA requests? And that would be FOIA officers. Each district agency processes its records request, and the primary point of contact will be the FOIA officer. The district does not have a central body within to handle FOIA requests, so each agency takes it upon itself to create their FOIA process, and the FOIA officers are the initial point of contact. So you have just been told you are your agency's FOIA officer, and you receive a FOIA request. What now? What's next? Where do I start? It can be very confusing. A great first step is to send an acknowledgement letter. It's a way to open the lines of communication with the requester. I will note that FOIA Express, if your agency uses FOIA Express, sends a very general acknowledgement letter to the requester, but creating your own acknowledgement letter will definitely help you in the process of the FOIA process. Our office recommends that FOIA officers respond to requests within the 24 to 48 hours of receipt of the request. The clock begins to tick upon receipt of the request. So if you have questions or issues, address them in the acknowledgement letter in order to have resolution as quickly as possible. The acknowledgement letter should address issue raised in the FOIA request. Acknowledgement letter should state when the request was filed and when it was received. The requester should know when you actually receive the request and when the FOIA clock begins to tick. The submission date and the receipt date may be totally different, and the requester needs to know when the clock actually starts to tick. Acknowledgement letter should include the FOIA request number. The FOIA request number is usually generated by FOIA Express, but if your office doesn't use that, you should have some type of tracking system within your agency in order to keep a record and keep track of the different requests that comes into your office. The acknowledgement letter should also have the request description included, and the description should be quoted verbatim. Note, you shouldn't summarize it, because if you summarize it, you may miss something that the requester really wants. So the description should be verbatim. The acknowledgement letter should also include the classification of the requester. Classification of the requester has to be determined early on. You have to figure out, is the requester a commercial requester, a member of the news media, or if it falls into the third category of an other use requester. Under DC FOIA, agencies must first determine a requester's fee category to ascertain that agencies may charge, to ascertain fees that agencies may charge to process the request. And requesters fall into one of three categories based upon the intended use of those particular records. Requester fee category cross provisions. Fees are assessed based on the requester's category and the use of the documents. Take a look at the requester and ask yourself, how is the requester using the documents? Is the requester a commercial company? Is the commercial news media? Is the commercial a nonprofit? Then you ask, how are they using these documents? Requesters fall into three categories. The first category is that of commercial use requester. The second category, non-commercial use requesters. And the third category is all others, other use requesters. The commercial use requester, the fees for commercial use include reasonable charges for the document search, document duplication, and document review. If it's a non-commercial use, these include requests made by educational institutions, schools, non-commercial scientific institutions, and news media. Agencies can only charge duplication costs for non-commercial use requesters. And if you don't fall into those commercial use and non-commercial use, you're another use requester. And documents sought for scholarly or scientific purposes, documents not sought for scholarly or scientific purposes by an educational institution or non-commercial entity. They're not sought by news media, and they're not sought for commercial use. The only fees you can charge when you're dealing with an other use requester, The charges are duplication and search costs. Nowadays, we don't do much duplication unless it's specifically requested. A lot of FOIA requests are email or transferred electronically in some sort of way. If you are able to give an estimate, the acknowledgement letter should include the possible costs associated with the request, especially if it's going to be a large amount and the requesters only stated they're going to pay $100. This should be an issue that you should bring up in the acknowledgement letter, so those issues can be hashed out early on, because time is of the essence. The clock continues to tick. Your letter should acknowledge, your letter should inform, as well as advise the requester. Acknowledge the amount the requester has agreed to pay. For example, some requesters will state in their request letter that they agree to pay $100 for a request. Include that in the acknowledgement letter. If you know that this request is going to require more payment, definitely start that conversation with the requester at that time. Inform the requester that you will advise them of additional costs if you don't know at the time of this letter. If the amount goes over 100, then that will require another set of letters or communication with the requester. But you will let them know if additional costs go over whatever they said that they were going to pay, or whatever they said or even if they didn't state that they were going to pay anything, you still need to let them know you're going to inform them of any additional cost. If an voluminous amount of information is requested, ask the requester if they would like to discuss narrowing the request. You should discuss the time frame, the large amount of information that's requested that you're going to have to review. Some requesters realize it's in their best interest to narrow the request when you discuss and let them know how long it's going to take. They may need the information really quickly, and they may need only a small amount, or you can negotiate to get them what they need as quickly as possible. So acknowledgement letters play a huge role. And like I said, the communication gates are open with this acknowledgement letter. Response time. Time is always of the essence when responding to a FOIA request. Always inform the requester of response times. Agencies have 15 business days to respond to a request for information. The Metropolitan Police Department has 25 days to respond to requests for body-worn camera footage. So 15 days is the initial date for FOIA requests, and 25 days for body-worn camera footage. When there are unusual circumstances, you may advise the requester that you will invoke a 10-day extension. Say, for example, you have to state the reasons for the extension and the expected date of the determination. You have to let them know that we're adding on to these 15 days, we're adding 10 more. And you may ask, what is considered unusual? You may have to search for information, collect information to examine a voluminous amount of separate and distinct records that are demanded in a request. A lot of individuals ask for emails, text messages, memos. They ask for a lot of different records, and this is unusual, and this is, a need and a reason for you to invoke that 10-day extension, because you know it's not going to be completed within those 15 days. And there Also may be a need to consult with another public body who has an interest in the records, or two or more components of a public body having a substantial subject matter interest in the documents. Another unusual circumstance may be where the Metropolitan Police Department has been unable to procure a vendor that is able to perform the redactions within that 25-day time period. So those are examples of unusual circumstances. And these are things that you should communicate with the requester so they won't have expectations of thinking that they're going to receive something in 15 days or the 25 days if it goes over that. The next two slides we have is an example of an acknowledgement letter. Ms. Sailor Moon is requesting documents from a DC government agency. November 17th, 2050, Ms. Sailor Moon, 1990 Hollywood Studios, Orlando, Florida, 12345. Her email address, csdisney@world.com. The FOIA request in question is 2050 FOIA 00123. Dear Ms. Moon, on November 15th, 2050, you filed a Freedom of Information Act request with the Agency of Cartoon Visions. Your FOIA request was received by the Agency of Cartoon Visions for processing on April 16th, 2050. Please refer to request 2050 00123 when communicating with our office. You requested the following: any documents, including emails or other work products from any official or DC government employee that includes the phrase My Hero Academia or Naruto or Pokemon or references to Star Wars. Date range for record search from November 18, 2040 to present. We have classified your request as an other use requester. Another use requester is entitled to receive 2 hours of search time and 100 pages of responsive records before being charged for search and duplication. We have forwarded your request to the Office of the Chief Technology Officer for a search of the requested emails. We have also forwarded your request to the Office of Cartoon Jr. for a search of its files. You should expect to hear from us shortly regarding the results of the search. Agencies usually have 15 business days to respond to a FOIA request. However, in this instance, we are extending the response time for an additional 10 business days due to the voluminous amount of documents requested and the need to consult with one or more offices within our agency. If you have any questions regarding your request, you may reach me via email at foiaofficer@cartoonvisions.gov or at 202-888-5555. Please have your FOIA reference number available when you contact our office. Sincerely, FOIA Officer. So I'm going to go back and go over some of the particular issues that stand out in this sample letter. This acknowledgement letter, of course, includes the date that the acknowledgement letter was sent out. We have the requester's contact information as well as the email address here, which is that would be straight from the request letter that was sent out. The FOIA request number, this is what the letter is regarding, so we put that up front as the subject. On November 15, 2050, that's when Ms. Moon filed the request. So we have that up front, but we also let Ms. Moon know that the agency did not receive the request until April 16th. Thereby, that's when the clock starts to tick from April 16th. The reference to the FOIA request number is also there, letting her know that's how you communicate with us. So we'll know who you are and what your issues are. The request description is verbatim. And what we have to pay attention here is the date range of the search. We don't know if it's going to be a voluminous request, but it is a huge possibility. With 10 years, she's saying the date range is from 11/18/2040 to present, and the letter is November 17th, 2050. So that's a 10-year date range. So it's a possibility it's going to be a broad request, depending on what the offices send back to you. So that is something that we would have to definitely pay attention to. Classified her as an other use requester. Let her know that 2 hours of search time are free, 100 pages if we have to, and 100 pages are free. And after that, then she may possibly be charged. On the next page, we're describing the process. We let the requester know that we forwarded her request to the Office of Chief Technology to search for the emails. And we also let her know that we sent the request to the Office of Cartoon Jr. We are consulting with 2 different offices, and that in turn is our justification for this 10-day business extension. We also inform the requester of the response time, which is 15 days, and that we're going to take that 10-day extension due to the fact the voluminous amount of documents that requested and the need to consult with the other agencies. And we let her know which agencies that we have to consult with. If by chance Ms. Moon had stated she wanted a fee waiver, that would be another issue that we would discuss in the acknowledgement letter, letting her know if the fee waiver would be granted or if it would be denied, or you would have to get back with her on that. That's an issue if that's brought up. So there are other issues that may come up depending on what the person is requesting and how much the person is requesting. Could be an issue on fees. She could have stated, I'm only going to pay $100 regardless. Like if you go over $100, I'm not paying it. So that could be a fee issue that you discuss. So correspondence may continue after acknowledgement letter, and you would want that to continue because if by chance you go to the requester files an appeal and you're in Superior Court or if it's the mayor's office, you have to show that documentation where you were communicating back and forth and where you were trying to process the request, and you have your reasons and your backup information on what happened, when it happened, and how things occurred. So we'll go over the acknowledgement letters may include the FOIA request number. They should include the request description, verbatim. The acknowledgement letter should include a discussion to narrow if the request is broad. The acknowledgement letter should include requester's fee categories. Very important. If you state that someone's a commercial requester and they think that they're an other use requester, then that conversation begins at that point. Then then the fee issue will change depending on what category you actually decide that they should fit into. Acknowledgement letters should address fee waivers, and acknowledgement letters should include response time. And as I said, depending on the request. Every request is different. It may be another issue that you haven't encountered that you may have to bring up and address at that time. Did somebody have a question? I'm sorry, I can barely. It sounds like somebody's asking something, but I can't really hear them.
Have a question, you're welcome to put it in the chat. We're having a little trouble hearing you. Thanks.
Okay. Here we are. We're looking at fees now. When a requester wants to submit a FOIA request, there is no fee to submit a FOIA request. I get calls every now and then asking how much it costs, but there is no fee for someone to submit a request. But there are fees for searching, reviewing, and reproducing records, as I stated earlier. Fees are based upon the classification of the requester. That's why it's important early on to get that correct, so we won't be charging individuals who should not be charged, and we should be charging individuals who should be. A FOIA requester may be charged fees even if the search does not locate responsive records or an exemption applies. And that's something that definitely has to be explained to the requester. Searching for records, the cost ranges from $16 to $40 per hour based on the pay grade of the personnel who performs the search, with the first hour being free. Charges for the initial review of the documents are $16 to $40 as well per hour based on the pay grade of the personnel who performs the review, with the first hour being free again. Photocopies, 25 cents per page. We usually don't see that too much anymore. As I said before, usually everything is emailed or sent electronically in some way. Document certification, $1 per document to certify a document as a true copy of an agency record. And when a response to request requires services or materials that the fees haven't been established, the direct cost of the services are usually charged. The government or material to the government may be charged, but if you notify the requester, but you must always notify the requester before the costs are incurred, because you don't know if they want to pay for that. So it's the different issues pop up all the time. If it's going to be a cost involved, anytime, make the requester aware, and especially if it's not a particular FOIA fee that's already been established, let them know. They may or may not want to pay for that. Fee waivers. A requester always has to ask for a fee waiver. A requester must include a statement in the request describing how the requested records will be used to benefit the public, and that's their justification for the fee waiver. Agencies have the authority to waive all the fees or part of any fee when it's deemed to be either in the agency's interest or in the interest of the public. So these are things that the FOIA officer, general counsel, you all have to decide whether you're going to grant this fee waiver or not. If the public body determines that a waiver fee reduction is in the public interest, a waiver or reduction may be granted. But there are a number of cases that fee waivers are denied as well, but you have to have the justification for that denial as well. Final response letters. FOIA officers must make the determination as to whether the request will be granted or denied. That's considered our decision letter. The final response to the requester is a decision letter, response letter. Decision letters must include whether the record was released in full, whether the record was partially released, or whether the record was withheld in full. You have to discuss fees if they're applicable. So fees are very important, and that stems from that requester category. So if you know that you're going to charge fees, that definitely has to be discussed in that decision letter or an acknowledgement letter or any letter in between, because that can be a sticking point with the requesters. If the requested record can't be located for some reason, it's been destroyed or it's been disposed of and you don't have it, the requester has to know. You can't just not tell the requester. You have to let the requester know that you don't have the information and why. If you have a final response where you are denying the records in full, you should include the identity of each person that's responsible for the denial, if that is different from the person who signs the request. Sometimes it may be the general counsel that's denied it or another attorney in the agency, or however your process goes. But the requester has to know who made that final decision on denial. A reference to the specific exemption or the exemptions that you used. You have to briefly describe how each exemption is applicable to each record that was withheld. Say, for instance, you have a one-page document, it's 3 paragraphs. The middle paragraph is the only one that's redacted. If you're using Adobe or FOIA Express, they have redaction tools where you can put where that middle paragraph that you took out, you can put exemption 6 there. If you need 5.2, you can put exemption 5. But in your decision letter, you have to explain why you use exemption 6 and the definition of exemption 6. You have to relay that to the requester so they know that you just didn't randomly take this out of the document. You also have to reference DC code provisions and case law if you use that as a basis of your decision. You have to include all of this in that decision letter. And if you're denying records, you always should have a statement advising the requester of their appeal rights, whether they go to the mayor's office first or they can go to Superior Court. But you definitely have to let them know that if they're not happy with this request, there is another route that they could take to try to possibly get the information. You have to make them aware of that. And by all means, do not procrastinate. Do not ignore a FOIA request. When the request is not processed within that 15-day time limit or that 25-day time limit, you have to let the requester know the reason for the delay. And if you have a very complete acknowledgement letter or another letter in between, by the time you get to that where you haven't been able to adhere to the 15 or 25-day timeline, that discussion is already coming into play. But if you haven't, for whatever reason, when that timeline comes, you have to explain why you're late, why there's a delay. You have to give an estimated completion date on when you're going to be able to determine when they'll get the information they requested, or if they may not get it. You may need to also suggest that your responses are going to come on a rolling basis. For example, we will release documents on the 15th of every month until we review the 4,000 documents you have requested. So that communication with that requester is very, very important. A lot of times the requester will hold off on an appeal because they know that you are at least working and trying to get some information to them. And during this time, you also have to let the requester know that this delay is considered a denial and they have a right to appeal. They don't have to wait on this every 15th of the month. They don't have to wait. But you have to let them know that they can appeal this delay. You can also ask the requester to forego the appeal until the determination has been made or you finish reviewing all the documents. So communication when you're dealing with the FOIA request is extremely important. Acknowledgement letters are extremely important. Letters in between, emails in between, constant, not, well, I wouldn't say constant contact, but contact with the requester will definitely help build a relationship, and they'll respect you because you're respecting them in the entire process, and things will go a little smoother. It doesn't always work out. Sometimes you find yourself, having to defend an appeal. But when you're working and you're communicating, everything's documented, and you can trace back to what you've done and what you're trying to do. Usually, things will work out, and the requester will be able to get what they need, and you'll be able to complete the request and possibly close it out. Director Allen is the district's advisor to FOIA officers, and the Office of Open Government provides formal as well as informal advice to agencies that are seeking guidance. The OOG advocates for fair and efficient FOIA processing, and we are also available to assist with FOIA requests. We are able to assist with the processing. You come up with an issue you haven't encountered before, give us a call. We'll try to help you as best as we possibly can. So if you have issues, questions, concerns, please just feel free to contact us and give us a call, and we will work through the issues with you. Here we have a list of our staff members. We're a small staff: Director Allen, Chief Counsel Barton, Attorney myself, Attorney Sheree DeBerry, Attorney Weil, Paralegal
Monique Jackson needs to mute, please. Sorry, I sent her a message before. Yeah.
Kimberly Brown, our paralegal specialist, Attorney Skirbo, and IT specialist Kevin Brown. We're all available to speak with. You can send us or call us, and we will be able to help you as quickly as we can. So feel free. That's what we're here for, to help. And as I stated before, our FY 2023 FOIA webinar series continues on July 25th and August 1st. On July 25th, the presentation will discuss FOIA officers' reporting duties and searching for electronic records. This presentation will be facilitated by the Office of the Secretary and OCTO. And on August 1st, that presentation will be dealing with preparing for a FOIA civil case, defensive litigation. And this training will be facilitated by the Office of the Attorney General. So I would like to thank everyone for taking the time to attend this training today. And if anyone has any questions, any issues you would like me to address, feel free to do so now.
I've got a question.
Sure.
Thank you for the presentation. I thought it was great. My
Thank you.
question relates to after you have put a request on hold, seeking further clarification. You put a request on hold, the request isn't perfected. You've reached out several times to the requester saying, I need more information to be able to do an adequate search. At what point, when they stop responding, can the request just be closed?
Well, the advice that we give here at the Office of Open Government, usually we reach out, send the clarification letter, let them know that that their request is on hold and that we can't continue until we receive this information. And usually, like the first request, we'll reach out 3 times. The first request, we'll give them 2 weeks to respond to us. The 2 weeks come, they haven't responded. So we'll send out another letter for 2 weeks. 2 weeks come, they haven't responded. Then the third request, we'll send out another 2-week time period for them to respond. If they have not responded within that time frame, then go ahead and close the request. And this here shows, say for instance, they pop up after, a month or 2 after we close the request saying, I'm going to appeal this. It shouldn't have been closed, but this will let the mayor's office, Superior Court know that, we timely, we tried to contact them. We tried to contact them over this 6-week period, no response. We closed the request. But a lot of times when someone does come back up and, we let them know that we've closed it, just let them know, well, you can submit it again. And I'll let you know these are the issues we had before we tried to contact you. But when they don't respond like that, we usually give them three different times over 3 different 2-week periods and then close it. If they come back up, then we just ask them to submit the request again and let them know the issues before, why it wasn't processed, and let them know that, we have to have some communication if you want this request fulfilled. So I hope I answered your question.
Yeah, that was great. Thank you for that.
You're welcome.
Can I ask a follow-up on that? Actually, when you say a 2-week period, do you actually say, here's your deadline, or do you just wait 2 weeks and try again?
No, we let them know in the letter that they have 2 weeks to respond. We let them know in the letter.
Okay.
In each try, the first, second, and third, we will let them know that they have 2 weeks to respond to the letter. Or, it's a possibility that the request may be closed and go from there. So usually if someone's serious about it, they'll respond within that 2-week time frame. If they're not, it's going to usually be closed. But we give a valid 3 attempts and 3 tries to let them know that we're still trying to work with you if you want to work with us. We have any more questions? Were there any questions in the chat? See any? Okay. All right, well, we'll end the training here, but if anyone has any questions beyond the training and would like to speak with one of us outside of this, feel free to give us send us an email or give us a call. And this training should be posted to our website shortly. And if you want me to send the slides to you, just send me an email and I will send them over to you. So thanks again. Take care and enjoy the rest of your